I'd like to introduce Professor Helen Hershkoff, the Herbert M. and Svetlana Wachtell Professor of Constitutional Law and Civil Liberties at NYU.
Thank you. Thank you. As you know, I'm Helen Hershkoff, and it's my honor to welcome you to the second day of this important conversation about state constitutions. I know many of you. I hope to know more of you after this conference. I welcome you as a member of the board of the Brennan Center, which, as you know, is co-sponsoring this symposium and trying very hard to save American democracy. I welcome you as a faculty member of this great law school. NYU has long supported the work of state courts through the Institute of Judicial Administration and the more recent Center on Civil Justice, and it offers not one, but two courses on state constitutions by Judge Rosenblatt, who is happily here with us and will be speaking later, and by Judge Sutton, whose work was repeatedly mentioned yesterday. I welcome you as a scholar who has written and continues to write about state constitutions and state courts. In 3 weeks, I am happy to say I'll be in Baton Rouge for a conference on the Louisiana State Constitution. I thank the NYU Law Review here, and I see a number of my students and former students involved with this event, and I thank them for publishing the remarks of some of the speakers. And I welcome you as a lawyer who back in the 1980s and 1990s, that must seem thousands of years ago for the students in this room, I worked in the trenches with a small number of advocates at the Legal Aid Society and then at the ACLU, looking to state constitutions to protect rights that were no longer available under the federal Constitution or had never been available under the federal Constitution. Rights to quality, desegregated public schooling, rights to housing for the unhoused, rights to public libraries that were accessible to all. As advocates, we knew that our legal focus had to be broader than the federal Constitution. As Daniel Lutz wrote in 1988, the U.S. Constitution is incomplete without the state constitutions. And as advocates, we also knew that litigation can never be transformational without communities mobilized and organized in political struggle. And in that spirit, I give a shout out to the Chef Movement, a coalition of parents, teachers, students, community members who were working then and still working to try to achieve quality, integrated education for all children in Hartford, Connecticut. Back then, state constitutional advocacy was an uphill battle, and it was pretty lonely. And on a personal note, I want to thank Robert Williams, who spoke yesterday, for always taking my calls. Bob was a rare cheerleader among academics. Most scholars voiced the criticism that you heard yesterday, that the turn to state courts and to state constitutions was lacking legitimacy. They dismissed our work, they dismissed my work, as reactive and opportunistic, a second-best solution to national problems. After all, they argued, even Justice Brennan looked to state courts only to fill a gap, to step into a breach that was caused by the end of the Warren Court. But as Bob Williams pointed out yesterday, that criticism took no account of the many jurists and scholars who had pressed state constitutional claims before Justice Brennan made his call to arms. And indeed, Justice Brennan himself acknowledged the groundbreaking work of Hans Linde, who as a professor and then as a judge in Oregon had called for state law primacy. The illegitimacy argument, to my mind, rested on a shallow foundation, a formal and somewhat empty notion of federalism. It saw federalism as a line-drawing exercise. It placed barriers between the states and the national government. Justice Brennan knew better. Federalism has a substantive component, and is devised as a dual protection for rights and liberties. Justice Liu elegantly expressed this theory of federalism in yesterday's panel. But critics savaged state constitutionalism in another way, questioning whether state constitutions even deserve to be called constitutions. They were instead laundry lists of special interest concerns filled with trivial details like the width of ski trails, now respectfully acknowledged by Judge Halligan as the forever wild clause of the New York State Constitution. To be sure, state constitutions include a number of provisions that are wholly absent from the United States Constitution. Unlike the federal Constitution, they recognize that democratic life depends on material conditions that go beyond protection of common law entitlements to contract and property. The American people need clean air, they need public schools, they need the right to vote, and they need assistance when they're down and out and can't work. But even if state constitutions were real constitutions, some critics said, so what? Given the ease of state constitutional amendment, these documents were said to draw more from Mary Poppins than from James Madison, pie-crust promises, more fragile even than parchment promises, easily made, easily broken, hardly the stuff of a mutable constitutional principle. Advocates certainly recognize the perils of amendomania. I litigated in Alabama, which had how many amendments? Over 400? But with Article 5 of the federal Constitution top of mind, we also cautiously saw democratic possibility in amendments, especially in those states that allowed for ballot initiative. The criticisms did not end here. Some critics insinuated that state judges were not up to the task of interpreting state constitutions. At best, they could march in lockstep with Article 3 judges. That some of the great judges were or began as state judges, think Brennan, Cardozo, Holmes, Traynor, got pushed to the side. Of course, that's not to deny that partisan selection methods and popular election posed a peril to judges who dared to step into the breach. They faced what Justice Otto Kaus of the California Supreme Court back then called the crocodile in the bathtub. But here we are again, almost a half century since Justice Brennan delivered his 1977 Meiklejohn lecture, focused once more on state constitutions, a restart said to be made more urgent by the Supreme Court's embrace of originalism, its refusal to redress partisan gerrymanders, its decision in Dobbs to return reproductive autonomy to the states, and its newly minted approach to stare decisis that, to my mind, puts equal protection, due process, and the work of the administrative state in jeopardy. The focus of today's panels, access to courts, reproductive autonomy, and politics, certainly echo from the 1980s and the 1990s. And so, to borrow from that great legal theorist, Yogi Berra, is this simply déjà vu all over again? I would say hardly. 15 years ago, scholars talked about the new judicial federalism. Today, they use terms like vigilante federalism. The crocodile in the bathtub seems warm and fluffy in the light of today's hyperpolarized, AI-generated, money-infused battleground of state judicial elections. But of course, of all elections, and also the federal judicial selection process itself. Yet as we heard yesterday, the California experience tells us that the electoral waters have remained calmed in some states. That's a data point that we need to consider. 15 years ago, the universe of state constitutional advocates was really small. Today, the playing field is populated by lawyers and analysts from both sides of the political aisle. There are lots of conservative think tanks and advocacy groups. There are attorney generals, red and blue. There are school boards. There are electoral commissions. And there are legislators of all political stripes. Some of these actors do not have state constitutional goals that are allied with Justice Brennan's vision of federalism and of democracy. Those goals include greater protection of property by eliminating the presumption of constitutionality for economic regulation, and selective disincorporation of the Bill of Rights. With respect, I join Abe Lincoln and say, this to me is no democracy. State courts are also different than they were 15 years ago. Just think how state courts were able to pivot during the pandemic because of improved administration and technological upgrades, and how state courts are able to use their administrative authority to improve judicial access. Consider the path-locking work here in New York on using administrative authority to improve access to counsel. But let's be clear. State courts need more funding, they need more equipment, and they need more staff to deal with dockets that are exponentially larger than those of the federal courts. They especially need more resources to deal with an outsized pro se docket because parties cannot afford counsel. Scholars now talk about lawyerless courts. Some courts also have partyless cases because so many cases are decided on default when a defendant, usually pro se, doesn't appear. This trend hurts real people, but it also hurts legal development, and in particular, it hurts state constitutional development. It hurts state constitutional claims because they're not likely to be raised in a case in which the litigant is pro se or the decision is reached by default. You heard yesterday judges bemoaning the fact that public defenders don't have the time to press and brief state constitutional claims from the outset of a case. Now, this is not to deny the value of big headline cases, affirmative cases, so-called impact cases filed on the offense. But state constitutional law also needs to develop on the defense. And as Judge Kaye, a graduate of this great law school and of the New York Court of Appeals, emphasized, sometimes state constitutional law develops in common law decisions that reflect state common law principles and values. And that process depends on having cases, real cases, in which issues are surfaced, histories are mined, records are developed, and arguments are pressed, a process that needs lawyers. What else is different? To their enormous credit, as we saw yesterday, some state judges are engaged in the very hard work of developing interpretive techniques for state constitutional cases. And those interpretive techniques build on but vary from federal approaches. Indeed, it borders on the incoherent to say that a state judge interpreting a constitution adopted in the 20th century should look to an originalist approach that depends on 18th century public mind and public view. These state constitutional decisions and these state constitutional approaches offer very important lessons for the federal courts if the federal courts are willing to listen. Consider the Massachusetts Judicial Supreme Court's decision barring life in prison without parole for anyone under the age of 21. And consider Montana's theory of predicate rights, the idea that a right can be fundamental if it is deemed necessary to the exercise of an enumerated fundamental right. Finally, let me suggest that all of us in this room need, to think twice before we accept some of the accepted wisdom, the consensus about the new and improved judicial federalism. Judge Earl already sounded the alarm yesterday in questioning whether federal rights indeed provide a floor to state constitutional interpretation, even when federal rights seem secure. And the example that she gave was equal protection. Well, you might say, if the federal courts step aside, if the Supreme Court refuses to recognize a right or eliminates a right, doesn't that leave space for the state courts to interpret their own state constitutions? Well, I would say not always. When the Supreme Court retreats from rights or refuses to recognize a right, keep in mind that its rights resistance or its rights minimalism can profoundly distort the interpretive space within which state courts do their jobs. As an example, consider the narrow democratic options that occurred in some states in the wake of San Antonio versus Rodriguez, when the Supreme Court effectively hardwired local control into state constitutions, even when the state constitution did not, in fact, include a commitment to local control. Moreover, without getting too much into the weeds of federal jurisdiction, anyone who lived through Bush versus Gore knows that the Supreme Court has ways to review a state judgment, even when that state judgment seems to rest on state law grounds. The independent and adequate state ground doctrine is a fragile wall between state judgments and federal review. And in addition, it's true that too many state courts import Article III justiciability doctrine into their state constitutions. That's actually an idea that got me tenure here. But don't be lulled into thinking that an independent state standing doctrine, allowing cases to be brought in state court that could not be heard in federal court under the new Article III doctrine, will actually protect a plaintiff's victory. There's a difference between standing at the get-go of a case and standing on appeal, and in particular, that will affect plaintiff's ability to retain a victory in state court. I watched Justice Brennan's 1986 Madison lecture in this very room on videotape as part of an overflow audience that I joined hurrying in late from my legal aid office. And I remember that the justice generated an incredible sense of optimism in state constitutions and in their transformational potential to achieve a more fair, inclusive, and fair democracy. Today's panels, this event, ignite a similar optimism, but we should not for a second ignore those voices of doom that urge realism and strategy about the limits and even perils of this approach. So I thank you, I welcome you, and now let's turn to our fabulous speakers.